Well, with regard to this visa waiver program adjustment, a lot of lawyers don't know you can file for adjustment of status on the visa waiver program if you're an immediate relative case. So that's if your spouse of U.S. citizen, parent of U.S. citizen, or minor child of U.S. citizen. The exception of it, the problem with it is that when you sign up for the visa waiver program and you enter U.S. ESTA, ESTA, you give away the right to have a removal hearing, immigration court hearing, unless you're going to file for asylum in immigration court. Other than that, you can't get immigration court hearing. And that so this really outlines that so people know. And what's going to happen is inevitably your 90 days is going to run out and the adjustment's going to be pending, so it'll be out of status. Historically, it was an issue, and a Trump administration sometimes will pick you up. And so it's really risky to file for adjustment of status in the visa waiver program because you don't get that backup. But an exception, again, a lot of people aren't aware of is that in the Ninth Circuit, there was a lawsuit, and it's in the footnotes here, that in the Ninth Circuit, if you filed the case within 90 days of entry, then you are able to get removal hearings. So the memo says that a VWP visa waiver program overstay whose case is denied by USCIS has no appeal rights and may not be placed in removal proceedings before an immigration judge. There is, however, an exception for cases filed within the jurisdiction of the Ninth Circuit. A visa waiver program overstay who is an immediate relative and whose Form I-45 was filed within 90 days of period of admission within the jurisdiction of Ninth Circuit is entitled to be placed in removal proceedings under INA Section 240 should the adjustment application be denied by USCIS. So there's 2 points there. One is that you got to file within 90 days. People are always afraid of this immigrant intent rule of 90-day filing and stuff like that. But people come and after a month or two realize they want to stay. So that immigrant intent historically has been a problem. Who knows under Trump how annoying they're going to be about it. But there's other part that says that's it. The application is denied by USCIS. In such cases, USCIS will refer the case to ICE for its consideration. USCIS may also issue an NTA before referring a Ninth Circuit case to ICE, and doing so is consistent with USCIS guidance on NTA issuance. So that sounds cool. You get the opportunity if your I-45 is denied to have a second hearing in court, which is great. And we always use that if there's Ninth Circuit and the client that changes their intent after entry. But nowadays, with the Trump administration just picking people up or out of status, you may not be able to get it because this memo it says that if the USCIS, if the case is denied, but what if their visa waiver overstay with an I-45 pending, then they get picked up. The case has not been adjudicated yet, so they might be able to they might be deported, removed based on being an ESTA entry, VWP, and the USCIS case is still pending, so it's not denied, so they don't get it entitled to it. So that's one of those things you probably want to file a lawsuit, habeas corpus kind of case, and then appeal it. And it's going to be a big Ninth Circuit thing because the language, no one would have thought ICE would have picked people up in these kind of situations unless they've been arrest history or something like that or criminal history. So that's something that might be problematic. You're going to have to jump and do lawsuits on. In the footnote number 13, it cites the court cases in the Ninth Circuit that allow immediate relatives to do it, but not preference cases. But it gets troublesome. But it's very important to know that these are possible.